begin the formal presentation, good morning. Members of the esteemed Colorado Supreme Court, specifically the Office of Attorney Regulation Counsel, representatives of relevant law enforcement agencies, and representatives of the Colorado Division of Workers' Compensation. My name is Starchild, and I stand before you today as an unrepresented claimant seeking immediate intervention and justice regarding a profound and ongoing pattern of professional misconduct, unauthorized interference with my medical care, clear HIPAA violations, and actions demonstrating severe bad faith within my active workers' compensation claim. This presentation will detail the egregious conduct of attorneys Gail Bennett and Heather from Pollard Miller and insurance adjuster Kathy Wall from Gallagher Bassett. I will outline the specific actions taken, the profound harm inflicted, the Colorado and federal laws that have been violated, and the immediate remedies I demand. I request for immediate action. I formally request your urgent and thorough investigation into the matters I am about to present. Specifically, I demand 1. For Gail Bennett and Heather, their immediate removal as attorneys representing the employer and insurer in my workers' compensation case, and that they be formally charged for the crimes committed against me. 2. For Kathy Wall, Catherine, her immediate removal from my workers' compensation case, and that she be formally charged for the crimes committed against me as well. 3. For True Blue, investigation into their knowing involvement in the unauthorized access and use of my protected health information and their role in the denial of my rightful benefits. 2. Background, my unrepresented status and critical injury. I am an unrepresented claimant in a workers' compensation case stemming from a severe work-related injury. This injury has tragically resulted in a diagnosis of complex regional pain syndrome, CRPS, and recently, autonomic storms. My unrepresented status throughout this entire ordeal has been consistently known to all involved parties, and I contend it has been exploited to my severe detriment. 3. The pattern of egregious misconduct and violations, the actions detailed within this section, committed by Gail Bennett, Heather, Kathy Wall, and True Blue, constitute direct violations of the specific Colorado and federal laws and professional rules of conduct, which are fully articulated with their corresponding punishments in Section 1B of this presentation. The actions taken by Gail Bennett, Heather, and Kathy Wall are not isolated incidents, but represent a deliberate and systematic effort to control, delay, and obstruct my medical care, and ultimately, to deny my legitimate claim. It is critically important to note that from day one, my singular and consistent objective, communicated clearly to the doctor's office, the insurance company, Gail Bennett, and my employer, was simply to find the problem, fix the problem, so I can go back to work. Every action taken by the opposing parties that obstructed my medical care, delayed my diagnosis, or forced financial hardship was in direct contradiction to this clear and consistent good faith directive. A. Unauthorized access and systemic sharing of protected health information, HIPAA violations. From the very inception of my claim, immediate unauthorized disclosure by insurance company, Gallagher Bassett, the insurance company, automatically shared my private medical information with my employer's corporate office. This was done without my authorization and constitutes an immediate and systemic violation of my medical privacy. Attorneys acknowledged knowledge of unauthorized origin. Gail Bennett received this unauthorized information from the insurance company from day one of my case. She was fully aware of its improper origin. Employers' knowing acceptance of unauthorized PHI, my employer, True Blue, willingly and knowingly accepted this protected health information, despite not having my signed authorization for its release to them. Failed authorization attempt followed by unauthorized action, Gail Bennett sent me a form to gain authorization to access my medical information. Crucially, I did not sign or return this form. Despite lacking this authorization, Gail Bennett subsequently proceeded to make my last doctor's appointment be the sole point of contact when this appointment was cancelled. Direct unauthorized dissemination by attorney Gail Bennett explicitly copied my sensitive medical information directly to my employer's corporate office. My doctor's office explicitly informed me that the employer is not privileged to this information unless I provide a specific HIPAA authorization, which I did not do. My employer gained immediate knowledge of my severe diagnosis, including torn tendons, underlying tears, and a hematoma, directly after I received the medical record due to this unauthorized sharing. These actions constitute direct and multiple violations of HIPAA regulations, as further detailed in Section IBB. B. Direct and intentional interference with medical care and treatment, beyond privacy breaches. There was a direct and devastating interference with my healthcare. Attorney's demand for control. Gail Bennett asserted an astonishing level of control, stating via message that all communications, including doctor's appointments, would have to go through her. This demand lacks any ethical or legal basis in an adversarial proceeding. Crucially, Gail Bennett is not a medical doctor, nor does she possess any medical authorization or expertise to dictate, manage, or interfere with a patient's medical treatment or appointments. Her actions represent an egregious overreach into medical decision-making, which is solely the purview of qualified healthcare professionals and the patient. Violation of established protocol for doctor selection. According to standard workers' compensation protocol, and as confirmed by the insurance company's own nurse, it is the responsibility of the insurance company and their nurse to initiate contact with the claimant to discuss and present different doctor options. The decision regarding the selection of a new doctor is intended to be a collaborative one, made jointly by the claimant, the insurance company, and their nurse. This critical and established protocol was entirely bypassed. Instead, Gail Bennett, an attorney with no medical authority, unilaterally selected and attempted to dictate my medical provider, demonstrating a direct and intentional subversion of proper procedure and a violation of my right to participate in my own medical care decisions. Circumvention of proper protocols. Laura, the insurance company's own nurse, confirmed the impropriety of this direct interference. She stated it was her job, as the designated nurse, to manage medical communications and appointments, not Gail Bennett's. Laura had no clue about Gail Bennett's involvement or the cancellation, highlighting severe disarray and a deliberate sidestepping of established protocols. Furthermore, I was supposed to have a local nurse from day one to accompany me to all appointments and liaise with Laura, a critical support system that was entirely absent. Deliberate delay and direction of care. Gail Bennett actively began making decisions on which doctors I could see. She, along with Kathy Wall, held up my access to a doctor for over 2.5 months. This unconscionable delay directly led to the delayed diagnosis of my CRPS. Laura, the insurance company's nurse, explicitly spoke out about the doctor they tried sending me to, Dr. Abrahamson, indicating her professional disagreement and concern with this choice. Laura, who is designated to be in charge of my health and medical coordination, confirmed that the decision to send me to Dr. Abrahamson was unilaterally made by Kathy Wall from the insurance company, and Gail Bennett specifically, against Laura's own wishes and medical advice. This highlights a profound disregard for appropriate medical guidance and internal protocols. Deliberate withholding of critical diagnosis from medical coordinator. It must also be noted that Gail Bennett, attorney Heather Dean McGraw, from Pollard Miller, and Kathy Wall, from the insurance company, deliberately withheld crucial information about my confirmed diagnosis of complex regional pain syndrome, CRPS, and my developing autonomic storms from Laura, the designated nurse at the insurance company. This withholding of vital diagnostic details from the person supposedly in charge of my health coordination demonstrates a calculated effort to obstruct proper medical management, deny necessary care, and further manipulate the course of my workers' compensation claim. These actions by Gail Bennett and others constitute violations of Colorado Rules of Professional Conduct, Colorado Revised Statutes concerning medical information theft, and workers' compensation fraud statutes, as further detailed in Section IVA, IVC, and IVD. C. Exploitation, coercion, and actions constituting bad faith. The overarching motivation appears to be a desire to leverage my severe condition for an unfavorable settlement. Deliberate creation of financial hardship and starvation. It must be known that through their concerted actions, including the deliberate withholding and delaying of essential medical care and benefits, Gail Bennett, the insurance company, Gallagher Bassett, and the employer, True Blue, have knowingly and intentionally forced me into severe financial hardship, directly leading to a state of starvation. This calculated infliction of distress was seemingly designed to coerce me into an unfavorable settlement, demonstrating an extreme degree of bad faith and malicious intent that extends beyond mere administrative delay to direct physical and economic harm. Pressure to settle while denying all real medical care. Throughout this period, despite knowing I had a very severe case due to initial improper treatment from Dr. Baker, and despite being aware my condition was getting worse by the day, both the insurance company and their attorneys repeatedly pressured me to settle, asking for my settlement demands, all while actively withholding and delaying crucial medical care. It is paramount to note that I have not received any real medical care to fix any of these problems since the date of the accident. This concerted effort to push for a settlement, concurrent with a complete denial of necessary and effective medical treatment, was effectively an attempt to force me to live indefinitely with a rapidly deteriorating medical condition without any prospect of improvement or recovery. awareness of catastrophic professional and economic ruin. It is also imperative to note that the individuals involved, Gail Bennett, Heather and Kathy Wall, along with the employer True Blue, were and remain fully aware that their deliberate actions would result in catastrophic and permanent professional and economic ruin for me. Specifically, they knew this would directly lead to the permanent loss of my Class A CDL, thereby preventing me from ever driving a truck again for my livelihood, the inability to proceed with making the major motion pictures I was scheduled to produce and direct as of right now, my complete inability to run my own companies, GTF Media Corporation, and Eclipse Nation shows, since the accident, effectively halting all my professional ventures and income generation, forced into public dispute despite known professional harm. It must be explicitly stated that from the very beginning of this process, I specifically communicated my desire not to see anybody or go after anybody in a public manner. As a public figure, I conveyed that such public exposure would cause immense professional and business damage, specifically within the entertainment industry, and would also jeopardize my ability to secure future contracts as a Class A CDL driver. Despite this clear and known professional vulnerability, and my explicit request to avoid public confrontation, the actions of Gail Bennett, Heather, Kathy Wall and True Blue have forced me into this public dispute, directly causing the very professional harm I sought to prevent. I strongly believe this is precisely why Gail Bennett continuously tried to pressure me into a settlement. This demonstrates an astonishing level of disregard for my well-being and a calculated willingness to inflict such damage to achieve their objectives, knowledge of whistleblower law violations by supervisor. Furthermore, it is imperative to note that Gail Bennett, Heather, Kathy Wall and True Blue are fully aware that one of their very own supervisors in the local office directly broke state and federal whistleblower laws concerning information about me, stating anything. This direct violation of applicable state and federal whistleblower protections, known to all parties, further contributes to the pervasive pattern of misconduct and the deliberate efforts to manage, control or suppress information related to my case, underlying malicious intent to evade broader accountability, based on their sustained and egregious conduct, including the deliberate denial of essential medical care and the relentless pressure to settle. I strongly believe that these actions were intentionally orchestrated because they were aware of a larger, systemic issue surrounding how the accident happened. Their concerted efforts were, in my conviction, designed to coerce me into closing out my claim and signing a release, thereby allowing them to evade their full responsibility and accountability for the true circumstances and underlying causes of my injury. These actions constitute direct violations of Colorado Workers' Compensation Fraud statutes and Colorado Bad Faith Insurance Practices laws, as further detailed in Section IBC and IBE. They also implicate Colorado Rules of Professional Conduct for Attorneys, as detailed in Section IBA. IB. Applicable laws, rules, and their punishments, the actions detailed above, are not merely ethical lapses, but constitute potentially criminal violations with severe consequences. A. Violations of Colorado Rules of Professional Conduct, Attorneys Gail Bennett and Heather. These rules are enforced by the Colorado Supreme Court through the Office of Attorney Regulation Counsel, OARC. Violations lead to professional disciplinary actions, not criminal charges directly from the OARC, unless the conduct also constitutes a crime. 1. Colorado Rule of Professional Conduct 4.3, Dealing with Unrepresented Person. Citation: CRPC 4.3. Violation: a lawyer, when dealing with an unrepresented person, shall not imply disinterestedness or give legal advice, other than to secure counsel, if interest conflict. Here, Gail Bennett exerted unauthorized control over my medical care and communications, acting in clear conflict with my interests while I was unrepresented. Illustrative case law principle. Decisions by the Colorado Supreme Court's presiding disciplinary judge routinely address situations where attorneys fail to properly clarify their role or give inappropriate advice to unrepresented parties, often leading to professional discipline. These cases emphasize the heightened duty owed to unrepresented individuals to prevent misunderstanding and unfair advantage. Punishment. Professional sanctions by the OARC can range from private admonition, a confidential warning, public censure, a public reprimand, suspension of license, temporary loss of the right to practice law from months to years, to disbarment, permanent revocation of the license to practice law. The specific sanction depends on the severity, intent, harm caused, and any prior disciplinary history. 2. Colorado Rule of Professional Conduct 4.4, Respect for Rights of Third Persons. Citation: CRPC 4.4. Violation: a lawyer shall not use means that have no substantial purpose other than to embarrass, delay, or burden a third person, or use methods of obtaining evidence that violate the legal rights of such a person. Gail Bennett's unauthorized access and dissemination of my medical information, coupled with her deliberate delays and interference in my medical care, violated my legal rights, including privacy and access to care, and served no substantial purpose other than to burden and harm me. Illustrative case law example. In re Rakin, 2025 CO12, a recent Colorado Supreme Court case illustrating a public censure, an attorney's conduct was found to violate COLO, RPC 4.4a, because it had no substantial purpose other than to delay, embarrass, or burden a third party. This demonstrates the court's strict enforcement of this rule to protect third parties from undue burden and rights violations. Punishment. Same as for CRPC 4.3, professional disciplinary sanctions by the OARC. 3. Colorado Rule of Professional Conduct 8.4, misconduct. Citation. CRPC 8.4. Violation. It is professional misconduct for a lawyer to c. engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Gail Bennett's misrepresentation of her authority, her control over my medical appointments despite lacking authorization, and her actions within a scheme to delay care and pressure settlement exemplify dishonesty and deceit. D. Engage in conduct that is prejudicial to the administration of justice. Her deliberate delays in my medical care, obstruction of access to necessary treatment, and manipulation of information to leverage a settlement directly undermine the integrity and fairness of the workers' compensation system. H. Engage in any conduct that directly, intentionally, and wrongfully harms others, and that adversely reflects on a lawyer's fitness to practice law. The severe harm to my health, including delayed CRPS diagnosis and cancelled vital appointments, and the deliberate nature of the actions demonstrate this. Illustrative case law principle. Numerous Colorado Supreme Court disciplinary decisions address violations of Rule 8.4, C and D, consistently imposing serious sanctions, including suspension and disbarment, for conduct involving dishonesty, fraud, or actions that obstruct legal processes and cause harm to others. Punishment. Same as for CRPC 4.3, professional disciplinary sanctions by the OARC. If the misconduct also constitutes a criminal act, the OARC would coordinate with law enforcement for criminal prosecution. B. Health Insurance Portability and Accountability Act, HIPAA. Violations. Criminal. Applicable to Gail Bennett, Kathy Wall, Gallagher Bassett, and True Blue. Citations. 42 USC Section 1320D6. Criminal penalties for HIPAA violations. 45 CFR Section 164.502a. This is the foundational rule stating that a covered entity or business associate may not use or disclose protected health information except as permitted or required by this subpart. This directly applies to Gallagher Bassett as a covered entity or business associate, Kathy Wall and Gail Bennett as a business associate or individual receiving PHI from a covered entity/business associate. It also applies to True Blue because, as your employer, they are not authorized to receive your medical information without your explicit consent, especially not in the detailed form it was shared. 45 CFR Section 164.508a. This regulation specifically states that, except as otherwise permitted or required by this subchapter, a covered entity may not use or disclose protected health information without an authorization that is valid under this section. This is the primary rule requiring patient authorization for most uses and disclosures of PHI, which you explicitly did not provide. 45 CFR Section 164.50ab. This section outlines the specific requirements for a valid authorization, including a description of the information to be used or disclosed, the purpose, an expiration date, and the individual's signature. Since you did not sign the form, any subsequent actions based on a presumed authorization would be invalid under this rule. 45 CFR Section 164.514d. Minimum necessary. This rule requires covered entities and business associates to make reasonable efforts to limit protected health information to the minimum necessary to accomplish the intended purpose of the use, disclosure, or request. Sharing your full medical information directly with your employer's corporate office far exceeds the minimum necessary for a workers' compensation claim, particularly when they are not involved in your direct care or payment processing in that specific capacity. True Blue's acceptance of this information also violates this rule. 45 CFR Section 164.530f. This rule requires a covered entity to have in place policies and procedures to prevent, detect, and correct violations of HIPAA. By accepting your medical information without proper authorization, True Blue failed to adhere to this requirement. Violation. This federal statute criminalizes knowingly obtaining or disclosing individually identifiable health information, PHI, in violation of the HIPAA privacy rule. The automatic sharing by Gallagher Bassett, Kathy Wall's involvement in this and her control over medical information, Gail Bennett's acquisition, use, and further unauthorized sharing of your PHI, and True Blue's knowing acceptance of this information are direct violations of 45 CFR Section 164.502a and Section 164.508a, as well as breaching the minimum necessary standard under Section 164.514D when disclosing to your employer. The attempted collection of an authorization that was not signed, followed by actions taken as if authorization was granted, further compounds these violations. True Blue's acceptance of this information also violates 45 CFR Section 164.530 F. Punishment. Federal criminal penalties. Knowing violation, up to $50,000 in fines and up to 1 year imprisonment. Under false pretenses, up to $100,000 in fines and up to 5 years imprisonment. With intent to sell, transfer, or use for commercial advantage, personal gain, or malicious harm, up to $250,000 in fines and up to 10 years imprisonment. My allegations, particularly the unauthorized sharing for strategic leverage in a claim, could fall under the more severe tiers due to potential malicious harm or intent to gain advantage. See Colorado Workers' Compensation Fraud, Criminal, applicable to Kathy Wall, potentially Gail Bennett, and True Blue. Citation: Colorado Revised Statutes, CRS, Section 843402, false statement felony. Violation: this statute makes it a felony for any person to willfully make a false statement or representation material to a claim for the purpose of obtaining or denying benefits, payments, compensation, or awards. Kathy Wall's alleged actions of delaying critical medical care, influencing medical provider choice, and cancelling appointments after a severe diagnosis, all while pressuring for a settlement, constitute a willful attempt to improperly deny or limit my rightful benefits. Gail Bennett's direct involvement in facilitating these actions could also make her liable. Furthermore, True Blue's complicity in the deliberate withholding and delaying of essential medical care and benefits, which directly resulted in my severe financial hardship and starvation, demonstrates their involvement in unlawfully denying or limiting my rightful workers' compensation benefits and could make them liable under this statute. The fact that Gail Bennett was told the employer was causing me financial hardship and they forced me to stay in work comp, with Kathy Wall going along with this knowledge, further demonstrates their willful intent to deny my benefits. Illustrative case law principle. Colorado appellate courts, in cases interpreting CRS Section 843402, consistently affirm that a willful misrepresentation or material omission intended to affect workers' compensation benefits, whether by claimants or other parties, constitutes fraud. The key element is the specific intent to defraud or manipulate the claim process. Punishment. This is a Class 5 felony in Colorado. Imprisonment. A presumptive range of 1 to 3 years in prison, with a maximum of 3 years. Fines. Up to $100,000. Mandatory parole period. 2 years following release from prison. D. Colorado Revised Statutes, Section the 18th of April 412. Theft of medical records or medical information penalty, applicable to Gail Bennett. Citation: CRS Section the 18th of April 412. Violation: this statute criminalizes, among other things, any person who, without proper authorization, knowingly obtains medical information with the intent to appropriate it, or who discloses it to an unauthorized person. While the statute uses theft, it broadly covers unauthorized access and disclosure. Gail Bennett's actions of unilaterally making and cancelling appointments and demanding that all medical communications go through her without your consent constitute obtaining and controlling your medical information and access to care without proper authorization.